Now, 1611's notice, which they even posted to me on 2011, they have already put it on for auction on 1811.
Auction was to be held on 2811.
2811, and they say 1811, they have already put it for auction. I have not even been put to notice. And now, if your lordship may kindly see, along with my petition, I have produced the panchnama of my car being seized.
I'll come to that point later.
Don't think this court would not understand that. 18th is the day on which you have given it to the paper for publication. The auction is supposed to be held on 22nd. Correct?
No. The word that I've already been heard Vignesh Shetty.
Definitely. Orders I have recorded.
Orders,
I have recorded every order. In every order what Vignesh Shetty has said. This is highly, I'm not on you, madam. Highly unfair practice on the part of the bank. So bank will be saddled with costs.
My lords.
Your bank official is here?
Yeah, he was here only. Yeah.
Let him become aware.
Yes, my lords. 5
lakhs will be the cost. Today, you have stepped in place of Vignesh Shetty. I impose costs. What will be it?
My lords,
what will be? Tell me.
I don't
know. The bank will say, because you have come on record, costs will be imposed. They will do that. Don't fall prey to the officials, the bank. This is why I said it was not shouting on you. It was on the bank. Advocate should not take the time shouting at them. I never shouted at any advocate.
No, this is just a desperate attempt of the petitioner to delay the recovery, my lord. I am a bona fide purchaser for consideration.
You're an auction purchaser, bona fide, yes.
I have followed the due procedure. I am a bona fide purchaser for consideration. Vignesh Shetty has not given invoice vakalat. Bank has insisted him to give invoice vakalat through mail. This is what the bank will follow the rules to get it done with the invoice.
I'm not bothered about the rules of the bank.
And the sale that is now questioned before your lordship is something that came to the notice of this court only after they filed a memo. Now this court has noticed that there is not even a day's notice given to me while the car has been sold. There is a memo filed before this court on 18/1/2024, my lord. If the memo may kindly be taken. 18 filed by the bank.
18/1.
Please, my lord.
The memo to produce notice postal receipt.
Please, that memo. And the first one is 16/11/2023.
What is 1611?
Registered post letter to the defaulting borrower, irregularity in payment on the head. This they claim is the sale notice to me.
1 minute.
Now, 1611's notice, which they even posted to me on 2011, they have already put it on for auction on 1811.
Auction was to be held on 2811.
2811, and they say 1811, they have already put it for auction. I have not even been put to notice. And now, if your lordship may kindly see, along with my petition, I have produced the panchnama of my car being seized. 1511 is the date my car is seized.
1511.
Panchnama, 1511.
Yes.
Toyota Innova anta. 1511 they seized that.
Yes.
And annexed of 1611, I have given a representation to them saying, whatever is the amount that is to be regularized, I will pay. As against Innova, there is no due. Please grant me opportunity. NP anta ಮಾಡಬೇಡಿ ಪೂರ್ತಿ ಎಲ್ಲ 4 ಅಕೌಂಟ್ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ತೀನಿ 4 ಅಲ್ಲಿ anyway this is not NPA Innova ಇರೋದು I will pay ಅಂತ I give a representation. In fact, there is a reply from them on 20th asking me to regularize it, which is at Annex G, page 58.
Page 58.
58, my lord. There is an email.
Yes.
If I may read that portion, my lord, with reference to your letter, we have to inform you that as per RBI guidelines, if one account is NPA, all other accounts are marked as NPA, even if the repayment for other accounts are coming. Hence, following RBI guideline, we have seized your car. We request you to regularize the SME term loan account in order to avoid further action in the matter of seized vehicle. This, they are giving it to me on 20th of November.
After putting it.
ಅದು auction ಹಾಕಿರೋದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ because technically ಈ 20th ನೇ ಆ notice ನನಗೆ ಸರ್ವ್ ಮಾಡಿರೋದು. The first notice they claim is also sent only on 20th. I have not received it at all.
Amen.
So therefore, my lord, I am here before this court seeking regularization. When I am before this court, this petition is filed on 4th of December. Then they say on 19th that it is already sold. Then I filed this memo.
I have captured all this in the
Please, my lord. Therefore, the sale is absolutely done without no notice to the person. And of course, that Innova against, there was not even one EMI pending.
Yes. Yes.
My lord, the first and foremost thing is that or an allegation it is that sale has been taken place on 18. That itself is a wrong submission. That for that
paper
publication published on the usually paper publication topple ಏನಿರುತ್ತೆ ಅದು ಆ ಡೇ ಪಬ್ಲಿಷ್ ಆಗಿರುತ್ತೆ. ಆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಯಾವಾಗ ಫಾರ್ಮೆಟ್ ಕೊಡ್ತೀವೋ ದಟ್ ಫಾರ್ಮೆಟ್ ವಿ ಹಾವ್ ಗಿವನ್
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ 18th ಅಂತ ಇದೆ. ಅದು ತಪ್ಪು.
ಅದು ತಪ್ಪು ಅಂದ್ರೆ ಅವತ್ತು ದಿನ ಆಕ್ಷನ್ ಮಾಡಿದೀವಿ ಅಂತ ಅಲ್ಲ. My lords, I'll come to that point.
Don't think this court would not understand that. 18th is the day on which you have given it to the paper for publication. The auction is supposed to be held on 22nd. Correct?
No.
ಯಾವತ್ತು auction ಮಾಡಿದ್ದು?
My lords, on 28th we have put it for auction.
When was the auction done?
28th only.
28th. The date on which the auction was fixed.
Yes, my lord.
Correct.
My lord, before that, earlier date of the court has asked me about the NPA. See, auction ella damil barutte. Let me prove on the NPA only. When the court has asked me, it is my duty that I
have not asked you anything.
Last date of hearing NPA ne agilla harakiri ella I mean you
I have asked questions to Vignesh which he has answered. I have not asked you any question.
The question was asked me only. If it is asked to the Vignesh Shetty, it's my duty that I should prove before the court.
Not necessary.
No, because of wrong submission of regarding the NPA only all these things have been happened.
No problem. Yes.
I may be heard on this, my lords.
Absolutely.
My lords,
tell me.
NPA regarding NPA, my lords. As the
ಎಷ್ಟು ಸೇಲ್ ಆಗಿರೋದು?
They claim it is 23 lakhs. 18 lakhs is the amount due. They have to state
at least 20% cost impose ಮಾಡಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Please, 23 lakhs is what they say.
5 lakhs cost impose ಮಾಡಿದ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ.
18 lakhs.
My lords,
tell me. Yes.
Yeah, before going to NPA, my lords.
No, you said NPA first. Go to NPA.
Yes, my lords. Madam, I am filing a memo along with the RBI guidelines where it is been mentioned regarding the NPA. Based on that RBI guidelines only, all the banks should act.
Correct.
I am just giving that.
Don't tell me rudimentary things in this court. If you do not know anything, learn. This court is aware. that RBI guidelines ಎಲ್ಲ ಮಾಡೋದು. That's all right. Now tell me.
Saying that this court is not outside.
Now tell me.
It's my
RBI, that's all right. RBI guidelines ಪ್ರಕಾರ ನೀವು ಮಾಡಿದಿರಾ. ಅದನ್ನ ರಿಪ್ಲೈ ಹೇಳಿದಿರಾ. RBI guidelines ಪ್ರಕಾರ ಒಂದು NP ಆದ್ರೆ ಎಲ್ಲ NP ಆಗುತ್ತೆ ಅಂತ. You want to tell that? Leave it. Yes,
my lords. If
I have heard Vignesh Shetty enough and more. I am just giving you audience. That's all.
Please
Only to impose costs. Yes.
No, my lords, please don't repeat the word that I have already been heard Vignesh Shetty.
Definitely. Orders I have recorded.
Orders.
I have recorded every
My lords,
order.
my
In
lords,
every order what
I'll take
Vignesh
my
Shetty has said.
Nani is wrong.
This is highly, I am not on you, madam. Highly unfair practice on the part of the bank. So bank will be saddled with costs. Definitely.
My lords,
ಎಲ್ಲ ಆಗಿ dictating orders ಅಲ್ಲಿ ಇದ್ದು dictating ಮಾಡ್ಬೇಕಾದ್ರೆ you change the counsel and try to say something else.
for that
No.
I'll give a justification for that.
No,
my
no,
lords.
no. I will not accept. I need not accept every justification of the bank. Yes.
My lords, if anything asked for me, then it is my duty that I
I have not asked you anything.
Allah, bank. See, I'm the bank.
You are not the one who was there earlier.
I'm representing the bank. My
Oh
lords.
no, you are not the one. You are not the one who was earlier here.
Correct, my lords.
Get Vignesh Shetty. I will hear everything. Yes.
My lords, when the invoice is given, then how?
No, no, I'm not.
Vignesh
This,
Shetty can-
that is what will be for imposition of costs on the bank.
My lords, if wrong submission made before this honorable court, obviously that order based on that submission only court has passed here. That itself.
So you are telling Vignesh Shetty has made wrong submissions.
That is why.
All right.
That is why, my lords, I am.
Record that also. You are telling Vignesh Shetty has made wrong submissions.
Please record it, my lords.
Yes, I will.
See, based on.
Anyway, it's on live streaming. It will be recorded. Don't
Please, my lords, please. For that only I'm here. Because for that only, see, I was not knowing all these things which has happened earlier. When the bank has come to me by, along with the invoice,
Your officer is here.
my lords,
Your bank official is here.
he was here only.
Let him become aware.
Yes, my lords. Agli,
5 lakhs will be the cost.
Yes, my lords. If it is
Yes.
proved, my lords, when they came to my office along with the invoice only, I got to know all these things.
Bank cannot play smart here, madam.
Bank only explained everything that.
They are
this-
before a court of law. This is not.
Let them be, my lords.
Yes, let them be.
No, my lord, because they have
What
to,
let them be?
if they are, my lords, or nange wrong information kotre, obviously my submission also will become wrong only. Let them give a right, right instructions for me there so that my argument will be in the right way only.
Now, whatever on merits you want to tell fast.
Merits, my lords, before getting into the merits, I want
Before
to argue.
getting only on the merits.
My lords,
Before
I am-
the court has got into other things 20 occasions earlier.
yes, my
Yes.
lords, I followed by the judgments, I wanted to argue on the maintainability of this honor. This
Yes,
case.
got it.
The law with regard to regarding to entertaining a petition under Article 226 of the Constitution in case of availability of alternate remedy is well settled. In the case of Satyavati Tandon Supra, this court observed thus. 43 point. Unfortunately, the High Court overlooked the settled law that the High Court will ordinarily not entertain a petition under Article 226 of the Constitution if any effective remedy is available to the aggrieved person, and that this rule applies with greater rigor in matter and involving recovery of taxes, cess, fees, other types of public money, and the dues of bank and other financial institutions. In our view, while dealing with the petitions involving challenge to the action taken, recovery of the public dues, etc., High Court must keep in mind that the legislation enacted by Parliament and state legislatures for recovery of such dues are a code unto themselves in as much as they not only contain comprehensive procedure for recovery of the dues, but also envisage constitution of quasi-judicial bodies for redressal of the grievance of any aggrieved person. Therefore, in all such cases, the High Court must insist that before availing remedy under Article 226 of the Constitution, a person must exhaust the remedies available under the relevant statute. This is regarding the jurisdiction, and though they have a merits, if so for that also there is a separate order, my lords. Kindly see page number
16.
no 26. Sorry, 23, my lords. This is the judgment of. I'll read the past details. High Court of Delhi judgment, my lords. Sanjay Dhingra versus IDB Bank Limited and others.
Yes.
Page number 23.
Yes.
Point 9.3. Where a remedy is available under Section 17 of SFC Act, this court ought to not to entertain writ petitions under Section 226 of Constitutional Law, and even on merit. The case of the petitioner is not sustainable. The petitioner had approached this court preliminary on the ground that since the loan was issued from the Dubai branch, proceedings under Section SFC Act would not be maintainable. In similar circumstances, Bombay High Court has already held that these issues ought to be properly agitated under Section 17 of SFC Act before the recovery tribunal, my lords. So when such being the case,
Not maintainable.
yes, my lords. If the petition is not maintainable, of course I'm on the merits only. Bank has not done anything wrong here. Bank has followed all the SFC measures, but it has to be discerned before the RT, my lords. As per these judgments also, I've given more than 3 more judgments. Kindly go through it. I don't want to waste the precious time of this honorable court.
No problem, really.
Before this honorable court, I
No,
will
no, you finish. You ಏನೇನ್ ಹೇಳ್ಬೇಕೆಲ್ಲ ಹೇಳಿ.
That's all, my lords.
ಅಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಏನೇನ್ ಹೇಳ್ಬೇಕೆಲ್ಲ ಹೇಳಿ.
Yes, my lords. That
All right.
in Satyavati case Tandon. They have referred Satyavati case Tandon. So
Satyavati is the basis, madam. There are many judgments written on after Satyavati Tandon that High Court should not entertain a petition. No, because you are vehement in saying that bank has done nothing wrong.
Yes,
I'm
my
telling you. See, Supreme Court has also said that where there is statutory violation, a writ petition even under the surface would be maintained. Even in its latest judgment, Supreme Court says so. Why statutory violation I'm saying this? Basic thing is, before you initiate any proceedings of seizure, sale or whatever, the borrower must be notified, correct?
yes, my lords. Because of that only we will
Correct.
communicate to notice.
Borrower notify ಮಾಡಿದಿರಾ ಇದ್ರಲ್ಲಿ ಅಷ್ಟೇ ಯಾವಾಗ ಮಾಡಿ
My lords.
after giving the paper publication
Yes, my lords.
on 18th of whatever date it is, for the sale would be on 28th. You issue a notice on 20th. Will that be in accordance with law? That's all. Don't fall prey to these officials of the bank who keep changing the advocates. You should be confident and conscious of what you say. Today, you have stepped in place of Vignesh Shetty. I impose costs. What will be it?
My lords,
What
I don't
will be?
know.
Tell me.
I don't
The
know.
bank will say, because you have come on record, the costs will be imposed. But they will do that. Don't fall prey to the officials, the bank.
Sure, my
That's
lords.
very important. You're a counsel, I'm telling you.
The thing is,
These people keep changing whatever tune they want. Don't do that.
yes, my lords.
You should have. If
My
Vignesh Shetty is also a counsel.
My lords,
He's
last
also
year we had-
a counsel.
I know him well.
You
He's
know
my
him.
brother advocate.
1 minute. He's also a counsel. You should never utter saying that Vignesh Shetty has uttered falsehood before the court.
No.
That's not correct.
He's not doing direct allegation. Bank
Direct-
told me such
That
things.
is what
I'm
I
just
told you.
telling that.
That is why I told you. Don't fall prey to these officers of the bank.
Yes,
And
I do understand.
mudsling another advocate. Tomorrow they will go to another.
My lords, this is my 16th year of practice.
Ah,
I
then,
saw so
yeah,
many.
take- you will
I saw
take
so
it.
many managers or officials.
Why do you
like
need
this.
all that?
See, they have been told me that when the court is told me that have you aware of the Vignesh Shetty submission and all and how you got the NOC and when it is my duty that I have to convey
That's
with
okay.
that's it.
You have
I don't want
you have
to-
done your duty. No problem. We will answer.
And one more submission, my lords, one more request in fact, but rather than submission, I'll consider this as a request. See, ನಾನು ಬೇರೆ ಯಾರು advocate ಏನು ಮಾಡಿದ್ದಾರೆ ಅಂತ shouting at me in the open court lighting that itself is
No,
unfair.
that's not
because
why
I'm
I did.
here.
This is why. This is why I said it was not shouting on you. It was on the bank. Advocate should not take the time shouting at them. I never shouted any advocate.
4 o'clock ಅಂತ ಇತ್ತು, but list ಅಲ್ಲಿ mention ಇರಲಿಲ್ಲ. Probably
That's all right. No problem. That is all right. That is all. Now, no court would have entertained any submission of this kind, because further hearing, if you change the advocate, that itself would draw adverse inference against the whoever employer it is, or the bank, whoever it is. I permitted you to argue. Yes, you want to make submission, you make submission. But that is not, and any shouting will be only on the on whom you represent, not on the advocate at all. I've never shouted on an advocate, will never do it unless situation warrants. Okay, now you ಹೇಳಿ. Yes.
My lords, this court has told me that even there is a statutory violation. According to me, there is no statutory violation at all. As rightly, court has told me that, asked me that, have you intimated the borrower regarding all this?
Ashte, that's all.
Yes, I have intimated.
Where is
And yes, my lords.
What
We have clearly explained everything regarding the NPA and also regarding the guidelines of the RBI, how your accounts has been considered as a NPA, though it is regular.
Because
though it is
ಒಂದರಲ್ಲಿ
regular.
ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲದರಲ್ಲೂ ಆಗುತ್ತೆ. That's what you have said here.
Yes, and moreover, my lords, he legal notice allenella, when he has come to the bank approaching a loan, since from the loan agreement, we have been intimating him, idagate, let it be the one or two alla. If you've taken a 10 accounts, 10 loans, if one account pays
That is correct. That is RBI guideline.
See, Andrew, no, they have saying that now namgenu intimation barlilla, they have considered NPA.
Madam,
Ignorance, my
one
concern is
minute.
that
This is notice. Before you put a property to auction, now they know why is a property here. Should not the borrower be notified of such auction?
been
Either
notified.
notice ನೀವು NPA ಆಗುತ್ತೆ ಅಂತ ಕಳಿಸಿದ್ದೀರಾ, no problem. This is not notice that is necessary in law. Beyond this, I can't tell you.
no,
This is
because-
not the then you make your submission. I'll consider it.
My lords, since from NPA only, we are supposed to intimate to the borrower this is how. And before getting into NPA, 1 month skip adagle, we used to say that it is not a demand notice. The word itself will say the demand. We will not demand anything. One month ಗಾಗಿ ತಕ್ಷಣ you have a risk. In another 2 months, it will skip into NPA and we have to proceed along with the law. ಅಲ್ಲಿಂದ start ಮಾಡ್ತೀವಿ request ಮಾಡಕ್ಕೆ. And when the third notice will be reached to him, continuously 3 months ಆದಾಗ NPA ಆಗುತ್ತೆ. After that, we will send demand notice. We are not requesting anything you. As we have earlier sent that, we have sent so many notices regarding the request. ನೀವು regularize ಮಾಡಿ ಅಂತ. Now we are demanding you through the statutory notice only. My lords. So, ಇಲ್ಲಿ ನಾವು statutory notice ನ under section 32 ಕೊಟ್ಟಿಲ್ಲ. As per the SOP of the bank. ನಾನು SOP ನೀನು ಕೋರ್ಟಿಗೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ along with the memo.
Now vehicle is in your possession?
Yes, not under my possession.
Yes.
In bottom of the said page number. The bank will hand over the possession of the asset to the borrower anytime after repossession, but before concluding the sale transaction, provided the bank dues are cleared in full or compromise settlement has been reached between the borrower and the bank. My lords, even though sale has taken place, as this court has confused, sale has been taken.
Confused?
Yes, my lords, because the earlier submission, that's all. 1811 ಅಲ್ಲಿ sale taken ಆಗಿಲ್ಲ. It was on
18 sale ಆಗಿಲ್ಲ. 28 ಆಗಿರೋದು.
28 it has been, sale has taken place, not the property sold. See, even after
Sale has taken place, whatever, on 28.
yes, my lord, sale has taken place, and after that, as per the SOP, and I'm producing sale certificate before this honorable court along with the memo.
Another memo?
Sale certificate, it is not there in the file. By oversight, it has not been given. So that will show that when the sale is confirmed.
11/12/23.
28 ತಗೊಂಡಾದ್ಮೇಲೆ as per the SOP as I read now, even till ಇವತ್ತು ನಾಳೆ confirmation ಆಗಿದೆ, till today he'll be having all the rights to close his account and to recover his property, whether the car or whether the mortgage, something like that. So we have confirmed the sale on 11/12/2023. More than that 15 days, he has a sufficient time, another 12 days. Whatever he is doing. And when you have been, you have been legally injured by the bank, what prevent you to go and approach DRT? It is into 23 only, when it was in the November time only. He did not approach DRT. He wanted to drag the matter because High Court case ಹಾಕಿದ್ರೆ ಅದು reach ಆಗಕ್ಕೆ ತುಂಬಾ time ತಗೊಳುತ್ತೆ. First of all, court ಮುಂದೆ ಬರಲ್ಲ. This is what their conception is. DRT ನಲ್ಲಿ date will be given by default and same day ಆಗುತ್ತೆ, and I'll stay ಕೊಡಲ್ಲ. This is what the concept of the other side, like petitioners. That is why it's my humble submission, my lords. They have not come with clean hands before this honorable court.
Yes.
point out one thing in the SOP that they have just given. ಕೆಳಗಡೆ ಮಾತ್ರ ಓದೋದು
ಮೇಲ್ಗಡೆ ಸೇಲ್
ಅಲ್ಲೇ ಕ್ಲಿಯರ್ ಆಗಿದೆ. ಆಫ್ಟರ್ repossession ಒಂದು ಫಾಲೋ ಮಾಡಿರೋದಕ್ಕೆ ಅವ್ರು ಜಸ್ಟಿಫೈ ಮಾಡೋದು there is absolutely nothing.
ಸೇಲ್ ಆಫ್ ವೆಹಿಕಲ್
ಸೇಲ್ ಆಫ್ ವೆಹಿಕಲ್ ಶುಡ್ ಬಿ ದ ಥರ್ಡ್ ನೋಟಿಸ್. ಅದಕ್ಕೆ ಮುಂಚೆ ರಿಸರ್ವ್ ಪ್ರೈಸ್ ಫಿಕ್ಸ್ ಆಗೋದಕ್ಕೆ 7 days ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಆಗಬೇಕು ಅಂತ ಹಿಂದಿನ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ. ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಆಫ್ಟರ್ repossession within 7 days ಫಸ್ಟ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಆಗಬೇಕು. 15/11 ಪಂಚನಾಮ, 16/11 ನೋಟಿಸ್. ಅದನ್ನ ಡೆಲಿವರಿ ಪೋಸ್ಟ್ ಮಾಡಿರೋದು 20/11. ಅಲ್ಲೇ ಬಿಫೋರ್ ಎಫೆಕ್ಟಿಂಗ್ ಸೇಲ್ ನೋಟಿಸ್ ಆಫ್ ಮಿನಿಮಮ್ 7 days to be given to the borrower.
My lord,
There is absolutely nothing stated.
ಅವ್ರು ಇಷ್ಟ ಮಾಡಿದ್ರೆ ಇಲ್ಲ.
There is absolutely nothing stated in the entire argument as to where is the compliance of their own SOP, where is the compliance of the due notice. That is my simple case when it comes to the sale of Innova.
Yes.
And one other submission, my lord. They just showed a 10/7/2023 notice ಅಲ್ಲಿ ದುಡ್ಡು ಕೇಳಿದ್ವಿ, ನೋಟಿಸ್ ಆಗಿದೆ ಅಂತ. That stood cancelled because 10/7 is that notice. Subsequent to that annexure R5 irregularity notice ಕೊಟ್ಬಿಟ್ಟು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಅವರೇ ನಮಗೆ ಬಂದು ಹೇಳೋದು. R5 is issued, 10/7 is this notice. R5 is issued to me
2710.
That is the basis for me to approach this court because I cannot go before the DRT seeking to regularize my account. Illi irregularity notice ಕೊಟ್ಟು 2710 ಗೆ 7 days ಅಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಂತ they come for seizure. Therefore I requested an additional week's time to say that ಪೂರ್ತಿ amount of regularization I'm willing to pay, give me some time ಅಂತ. ಅದನ್ನ ಕೇಳೋದಕ್ಕೆ I cannot go before the surface court. And in that irregularity notice is the last communication to me. And they have sold the vehicle.
Yes madam, put madam.
My lord, may I submit before this?
ಮತ್ತೆ ಆಯ್ತಲ್ಲ.
Yes, ಅಲ್ಲ ಅವರು ಇಂಟಿಮೇಷನ್ ಇರಲಿಲ್ಲ, ರಿಸರ್ವ್ ಪ್ರೈಸ್ ಫಿಕ್ಸ್ ಮಾಡಿದಾಗ these are all internal procedure of the bank. No need to send a notice regarding the reserve price fix because that reserve price
ಬಗ್ಗೆ ಏನು ಹೇಳಿ
ಹೇಳಿದ್ರು 7 days ಅಲ್ಲಿ ಅವ್ರು ನಮಗೆ ನೋಟಿಸ್ ಕೊಡಬೇಕು.
SOP ಹೇಳಿದ್ದು.
SOP ಅದೇ ಆ SOP ನಲ್ಲಿ we are supposed to send a notice ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಆ ತರ ಅವ್ರು ಕೊಡಕ್ಕೆ ನೆಸೆಸರಿ. And ಏನೇನು ರಿಸರ್ವ್ ಪ್ರೈಸ್ ಫಿಕ್ಸ್ ಆಗಿರುತ್ತೋ that will be in the auction notice only. And moreover my lords, if I come to conclusion that as this court has said ನನಗೆ last time ಅದೇನಿದೆ you have to give the vehicle back ಅಂತ ಹೇಳಿದೆ, what could be the consequence? ಅದು ಒಂದ್ಸತಿ ನೋಡೋಣ within 1 minute.
ನೋಡೋಣ.
Yes, no my lords, no ಆ ತರ ನಾನು ಏನಾದ್ರು ಕೊಟ್ರೆ see account is closed from the purchaser, not from the borrower.
Purchaser is also here.
ಅಲ್ಲ ಅದೇ ಅವರು ಇವಾಗ ನಾನು ಏನಾದ್ರು ವೆಹಿಕಲ್ of course as this court aware that RTO ನೆಲ್ಲ intimation ಕೊಟ್ಟು it is not transferred to his name. So still it is my lords,
I'll tell you one thing.
This is conclusion my lords.
I'll tell you one thing. Conclusion early. Don't think this court is powerless to undo everything. These are all trivial official acts which will straight away be blown by a writ order.
I do understand.
So don't harp on that.
I know, I do understand.
Yes.
Thing is, ಇವಾಗ ನಾನು ಅವರು ಕೊಟ್ಟರೆ they are not supposed to take the vehicle back because
No problem.
because
That
let them pay. ಇವಾಗ ಅವ್ರು
what order should be passed, I will pass. ನಿಮ್ submission ಏನಿದೆ ಅದು ಮಾಡಿ.
Yes ma'am, that's only I'm doing. No, in one last submission. So ಅವ್ರು ಏನಾದ್ರು ವೆಹಿಕಲ್ ನ ಅವ್ರಿಗೆ ವಾಪಸ್ ಕೊಡಬೇಕು ಅಂತಂದ್ರೆ this account is closed for 49 lakhs odd. ಅದನ್ನ ಅವರು ಪೇ ಮಾಡಬೇಕಾಗುತ್ತೆ. So ಅವಾಗ ನಾನು ಅವರಿಂದ ತಗೊಳ್ಳೋ
We'll see about all that. That's a consequential action.
because account is closed from the purchaser, not from the borrower.
We'll see.
Lord,
Yes.
my submission is that, my lord, the loan was declared as an NPA on 29th June 2023, my lord, 29th May 2023. My lord, subsequent to that, there was a seizure notice, which is the impugned document, which is being challenged by the petitioner, dated 2nd June 2023.
2nd June?
2nd June 2023, my lord. Which is that,
Yes.
may I take a lordship to page 46, my lord? This is the irregularity notice, which was issued by the bank, which clearly states, my lord, that an action under surface can be initiated without any further notices.
Page, madam.
46, my lord. Well, the last paragraph, my lord. In case any of your accounts becomes NPA,
Yes.
regular accounts will be also treated as NPA. In the
That is as per the RBI guidelines.
Please, my lord. So the RBI guidelines has been complied by the
Bank will be compelled to initiate actions deeming fit, engaging services, so seizing so on so on so the cost of recovery met by.
Please, my lord. My lord, now the petitioner highlights that he has not been sufficiently intimated or properly intimated before the sale, before the property was put up for sale, my lord. My lord, even considering this submission of the petitioner, my lord, there was a span of 1 year between the loan being declared as NPA and the property being put up for sale, my lord. My lord, almost 1 year has passed by and there has been no attempts by the petitioner to regularize the bank account before the sale notice was issued. The irregularity notice was issued. Only when the vehicle was seized on 16 November 2023, he runs to the bank seeking for regularization of the account. 15 members. My lord, keeping this in view, even there is no attempt, not even a single attempt, my lord, not even a mail or nothing has been substantiated or demonstrated by the petitioner to establish the fact that he has made his attempt to regularize the account. My lord, this is just a desperate attempt of the petitioner to delay the recovery, my lord. I am a bona fide purchaser for consideration.
You're an auction purchaser, you're bona fide, yes.
I have followed the due procedure. I am a bona fide purchaser for consideration. Lord, I am producing 2 citations which your lordship will be aware of it, my lord. I have mentioned the relevant paragraphs in the memo as well. My lord, the PHR invent education.
That he has also relied on, yes.
Dwarika Prasad was state of Uttar Pradesh. My lord, this clearly states that, my lord, sale certificate can be redeemed only when there is a fraud or collusion, my lord. Paragraph 26, page 9 of the compilation.
Yes.
In our view, the High Court ought to have taken into consideration that the confirmed auction sale could have been interfered with only when there was a fraud or collusion. The present case was not a fraud or collusion. The effect of the order of the High Court would be again reopening the issues which have achieved finality. My lord, in this case, my lord, there is no fraud or collusion. That has not even been.
There is no fraud or collusion.
Yes, my lord. Even the fact that the petitioner contends that he has not been sufficiently intimated, my lord, I cannot be made a victim to the procedural lapse by the bank. My only submission is that, my lord, let the sale certificate not be redeemed. Whatever has to be compensated to me can be directly compensated to the petitioner.
All right. Yes. Anything else, sir? Heard reserved.